Okay, so this was...
We're not going to talk about movies again?
No.
Okay.
No. This is a case that, because we did,
Yes.
and I think we want to talk about this just because of the enormous amount of discreditable conduct, bad evidence that existed in the case. Like, it was from start to finish one giant character assassination.
Mm-hmm. And we're talking like
This is the finished
over
one.
the period of 23 years.
No.
Yeah, it's a finished one.
Yeah.
A relationship that went on for 23 years, and the allegations span the entire time frame. And so in describing this, there was actually what I call an essay written by the complainant
Oh, that one.
that just goes
Right in front of you.
Yeah,
Like-
I know.
like,
It's-
every
We're
single...
not going to disclose any names
No
or anything. We're going to
names,
be
no-
really careful.
It goes through
careful.
essentially 23 years of a life of hell that's dramatically written up in this essay, in which there's absolutely nothing about her husband that can be said was good
Well, there obviously
from
wasn't.
from even
clearly.
before the marriage. That it's just
No,
this
we're going to give an
nightmare.
example of this. So, but
So
the
bad.
point of this, what we're doing right now is that, so there's two charges, one count, but the second count was more interesting because it spanned 21 years of endless sexual assaults, just endless.
Right.
Oh,
Hundreds.
with other thrown in there, but just literally hundreds. That was the complaint. Okay.
Wow.
Just understand, one count over 21,
One count.
22-year period, hundreds of allegations of sexual assault, like hundreds.
As well as allegations of assault that are uncharged.
Right.
Yes.
Just nonstop.
You told me about
so it
that,
was
yeah.
one incredible, giant supernova
Vomit.
of bad character evidence, okay? And when do you do everything you possibly can to ensure you challenge prior discreditable conduct or bad character evidence? Or when do you just say, F it, we're going to lean into it? This is from a strategic point of view. Okay, so let's just start off with the law. 1, prior discreditable conduct.
Which is usually led by the prosecutor.
Prosecutor.
Usually, I try not to lead it against my own client.
No.
But is presumptively inadmissible.
Right.
And bad character evidence is presumptively inadmissible. And that can span lots of things short of a criminal offense, right?
Right.
So the rule on bad character evidence, thank you, Justice Watt. I'm just looking at your manual. It makes it easier for me.
Great book. We've ordered an extra copy.
We always have it. I mean, we
Yes.
have upstairs, we have tons. But it's
Oh,
just
yeah.
this is just simple for me to do it right now.
I know.
So, as a general rule, the Crown's not permitted to adduce evidence of the accused bad character for the sole purpose of proving that the defendant guilty of the offense charged on account of bad character. The rationale that underlies the rule is not so much concerned with relevance or lack of it as it is with fear of prejudice and compromise of the accused's right to a fair trial. The general rule is not without exception. Evidence of bad character may be adduced where, 1, it is relevant to an issue in the case otherwise than through a prohibited chain of reasoning. 2, the accused puts their character in issue, and that can happen. Or it is adduced incidentally to proper cross-examination of the accused on the issue of credibility. The evidence may be used in assessing the general credibility of the accused, but not to prove guilt by reason of bad character. So it's propensity-based. Because you're a shitty person doesn't necessarily mean you committed this offense.
Or more likely to have.
Or more likely to have committed it.
Right.
And there can be an issue that's relevant, especially if you're dealing with a domestic relationship over the period of time. Bad character evidence may explain delay in reporting, for example. That's just one example.
Domestic histories.
Yeah, so how about, I talk a lot. Why don't you say, so you have a domestic situation, hasn't been reported in 23 years, hundreds of sexual assaults, lots of abuse. How's bad character evidence relevant to delay in reporting?
You mean from the Crown's perspective?
Of course.
Of course. Well, because
that's all we care about.
That's all we care about. Well, because it's a history and it's relevant. It's how she's decided to cope in this relationship, and it's part of the narrative of the Crown.
So it's explaining why she behaved the way she did, why she stayed within the relationship because the husband was domineering was abusive. I was scared of him. I had
get
no way
out,
out.
no
I was
way out.
trapped. Because of this domineering, highly abusive, highly manipulative behavior, this is now the narrative of how eventually it came out, but I couldn't report for X number
For
of
X
years.
number of years.
Of course, it becomes more relevant when the defense is trying to raise questions about why the person stayed in the relationship. But it can be used for some purposes, with a warning that it can't be used as propensity evidence.
Right.
At the same time, like we have leading cases from Ontario Court of Appeal are RVMRS 2020, ONCA 667.
Right.
It's written by Justice Pacheco, and it does a good job. He's very accessible to non-legal people in the way he writes the decisions.
And legal people.
So it's kind of a good case to look up to understand the issues. But, it specifically says narrative.
Yeah, go ahead.
Just relax.
He is.
Settle into the
been a long
discussion. That narrative is not a portal for gratuitous propensity evidence about uncharged similar acts. So there's a difference
I
between
like that phrase.
Yeah. So
So the law has tightened up in the last several years with MRS and the other case, ZWC, where it's really tightened the relevance and admissibility of prior discreditable conduct, bad character evidence. They've done a very good job of tightening up because it was much more loosey-goosey before, leading to, unsafe convictions.
So, but there is a difference too between uncharged allegations being made and similar act of multiple charges. And they say if you find the person guilty of one, you can use that to determine.
Yeah, we're getting ahead of ourselves in this because that's not so relevant in this case. But you're right; these areas mesh. But let's just focus on bad character evidence and then prior discreditable conduct of allegations in a large global charge, and maybe some that aren't charged. Okay, but let's just say it's about this person is a shitty human being and did lots of bad things to me. Okay, and this is a strategic issue now. What do you do? Okay, and so in a case where you get, for example, not in the statement, the interview with the police officer, but in a separate document, a outline from the complainant about a history of abuse, where the abuse starts almost at the beginning of their relationship prior to being married and continues throughout that relationship. And the person produces a 8-page document on all the shitty things this person has ever done.
Right.
Like everything, including
Comprehensive.
nonstop abuse, all sorts of stuff.
And it's not even like a journal entry. This is almost written like a performance piece meant to be published on a website for survivors.
Right.
Well, a lot of this
using language that the person says that they've now learned about.
Right. Very inflammatory stuff.
Yeah, and this document comes out right at the time of the matrimonial litigation, but it's there's stuff in here like I'm the consistent parent, arguably the only parent. I am the safe, reliable, dependable, honest, engaged, caring, loving, secure parent. All he has done is interfere with that. He does not have the kid's best interests at heart, only his. In my opinion, he needs to, whatever. That's just one example. From my experience, he yells. He yells at me for going out with my girlfriends because I don't invite him. He yells at me for having a good relationship with my mom because he's not getting along with his. He yells at me for running at night because that's when he's home. He yells at me for doing things with the kids because I don't also do those with him. He forbids me from doing masculine things like cutting the lawn and painting anything on the exterior of the house. He yells at me for hiring a cleaning service once per month to help me out around the house because he never does. He yells at me about family dinners. He yells at me about about our spending. He demands relationships with the kids, even though he doesn't earn them.
That one is interesting.
He does not make time for family. He demands time when he has nothing else to do. He makes everything about him how he feels. In my opinion, he's a narcissist and a psychopath. I sounded kind of like a Dr. Seuss book here.
You
for a
really
moment.
did. The rhythm was getting was pretty good.
I'm not going to go on. That just gives you an example, okay? So, defense counsel.
And that's the nice thing she had to say about her.
So, defense counsel.
Those were the nicer
that was the good stuff.
That was the good stuff.
So, defense counsel. Let's talk. This is a collaborative effort here.
So one of the
When
first
this airs,
things,
feel free to make the comments as to what the you do, okay? So, you read a document like this, okay?
you scratch your head.
And it's like, so first question, after all the, let me do it in a hypothetical because I don't want to disclose anything. Hypothetical, the evidence goes in chief like this. First question, is there anything nice you have to say about your ex-husband?
anything?
No? Okay. Where do you go with this? Where do you go with this? What do you do? Because you know, okay, about the dangers of propensity reasoning. You know about the dangers of uncharged offenses. You know about the dangers of prior discreditable conduct. And you know full well that if you lean into all this, on appeal if you lose, somebody might say you f***ed up because you could have challenged a lot of this prior discreditable conduct evidence.
Why didn't
and
you
also
object?
the defense brought the evidence into play through presenting this document to.
Well, just let's assume, let's take two scenarios. Let's
I was gonna
assume
say,
one.
what's scenario one? We are using this?
Wait, scenario one, you don't object to this evidence going in, and the Crown essentially lets the complainant
Babylon.
testify about
Wax poetic.
Yeah.
right?
Poetic.
Bury.
Yes.
You don't object.
Right.
On appeal, client's convicted. What, are you in trouble on appeal on that?
Yeah.
Why?
Why didn't you object, Mr. Burry? You let all this bad character evidence go in without blinking.
Because it may not be relevant to the counts in the indictment.
Yeah, exactly.
So there is a danger that if you don't preemptively object to this and force the Crown to a pretrial motion, that on appeal, you could be, what are you complaining about?
Yeah, you sat there.
Now, let's say the Crown surgically puts in the evidence. Okay, surgically puts in the evidence. 25% of this gets in. And you're sitting with this document and you're going, oh, f***. Some of this stuff is just irresistible. Like,
Right.
he
so
demands
over the top.
relationships with, he
over the
demands
top.
relationships with the kids. He doesn't earn them. And this is at a stage when they're in family court proceedings. The kids are older,
Right.
but still can be influenced, okay? He makes everything about him, in my opinion, he's a narcissist and a psychopath. You've got a list of stuff like this. Like, what do you do? Because I got to tell you, it's just too fucking juicy not to cross on.
Yeah.
Right, because it tells you something about
Animus. Total animus.
about the complainant's approach to the relationship, and the complainant thinking that not encouraging a relationship between the father and child, and thinking that he has to earn the relationship. What does that even mean?
Yeah, with this. Yeah.
Does not just loving a child mean that you
Right.
earn friendship with them and a good relationship with them? I'm curious,
Pray do tell.
So there's the Shakespearean term, expression that I always get wrong.
No, what's that? You go.
She
you're
doth
all-
complain. Me think the lady
Me
doth
think
complain.
the lady doth complain too much, methinks.
Protest too
Something
much or
like that.
Somebody will correct me
Yes,
when
please
this
do.
airs and will tell me right, because I don't have my Shakespearean novel handy. But you complain so much about it.
Right.
It's like the law of economics, of diminishing returns. You complain so much about it, at some point it just seems too much.
Sounds ridiculous.
Well, and the nature of the complaints too is like, when there's an alleged breaking point over some minor thing,
Right.
the breaking point wasn't over the alleged assault or the alleged sexual assault. The breaking
Something
point is over
ridiculous,
some
yeah.
minor domestic dispute, argument.
Right.
Pickup of children.
Right.
Yeah. He was supposed to pick them up and
Right. So
and
what you're
whether or
saying
not-
in this case also, within this narrative, there was a portion where the complainant had said, this was where I was no longer invested in the relationship.
I checked out.
We had an argument about the children, and he didn't pick them up, and I showed him it's his fault, but I've checked out at that point. Okay, whatever. Okay, yeah, but it's just too juicy
Right.
because nobody can be that absolute of a fucking dick. Okay, I imagine there could be someone,
Close,
but like,
but not this bad. This
but
is
we know the
ridiculous.
relationship, and this was a lot. This was heavy. Do you lean into this and not object to this evidence? Because now on scenario 2, you're now introducing this essay and cross-examining and introducing a ton of bad character evidence and uncharged criminal offenses.
Specifically mentioning concern about who was going to get custody of the children.
That's right.
Undeniable that that's not really an issue in litigation anymore because the children are of age to make a decision who they want to live with on their own. But
Parenting time.
it still doesn't take away from the fact that the complainant may be intentionally manipulating the children
Alienating
and
them, yeah.
alienating the father.
For sure.
Okay, so it's still relevant, although not as relevant when you have some children are younger and you're fighting for sole custody. But this was just one of these rare cases we dealt with where it was an unbelievable amount of uncharged offenses lumped into one of these counts, and a huge amount of you're mad at me because I hire a cleaning and you don't do anything, you don't do this. It was just I couldn't resist.
This is bad.
Yeah.
This is
And
pretty
you know,
bad.
the other case we kind of mentioned, ZWC, that's RVZWC 2021 ONCA 116. So that was, a little bit after the MRS case, and it was an interesting one too. They give examples. This is a case where a bunch of things were made, uncharged allegations were made in advance in a statement, but when the complainant got up and testified, just started blurting out all these extra allegations
course.
nobody had ever heard before. So a mid-trial application was brought by the Crown to try and put that evidence in, but they clarified which stuff, and then they said other things shouldn't be considered, but they wanted to bring in this extra stuff. And they give examples of things that they anticipated were going to be testified to, that he hid a knife under his pillow and said his wife belonged to him. For 8 years, he sexually assaulted the wife while she was menstruating, sexually assaulted within 10 days of giving birth to a child. Right after birth, he slapped the wife on the ear, grabbed their daughter by the hair, stepped on her head, threatened to assault her if she reported any abuse to the police, used a cleaver to chop off the end of a table after hurting himself, numerous instances of grinding his pelvis into her or on top of his daughter in bed and in the shower, threatened the daughter not to tell anyone, shoved her head into a wall, called her a dirty whore, pinched and hit the daughter, climbed into bed with the daughter, rubbed his penis against her thigh on occasions other than the two similar charges. So we're talking about all of this uncharged.
Just a few things.
Just a few things.
Just a few
Yeah.
things.
And this is not uncommon. Like, the MRS case that we mentioned earlier was very similar. And these are just massive
The MRS case
list.
was a massive host of allegations.
Didn't bring her food to the hospital when she was giving birth. So it includes minor things like that, but they're all intended to say this is a despicable person who cares about nobody but himself.
And again,
He's
look,
a narcissist
Look,
or a psychopath.
we're not saying these scenarios don't happen. We're not saying that there aren't
No.
people out there who behave this way and are completely domineering and bad. But that's the case, and they talk about there how important it is to object to this and delineate and for a court to set out what's admissible and why it's admissible and what it's relevant to, right?
Or your favorite phrase. Remember when they started doing the character assassination?
Yeah,
You say, are you done? Do you remember my question?
I do. But I really want to harp on this one episode simply because I just want to talk strategy here.
Right.
Because, we don't have the decision in this case yet, but it was one of those strategic decisions where it was like there was so much, knowing our client and everything else, it was just very hard to accept. And we'll see.
Well, and there's
what happens,
contradictions too in terms of reasons given why the complainant decided to marry this person after many years of the abuse having already begun, right? And claims about fear and such, but then contradictory claims about the reasons for deciding to get married.
This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, Move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you. To put a tiny bit of meat on it.
Yeah.
So the abuse starts just right when they move in together, and they get engaged a year or two later, and then they get married a year or so later than that.
Right.
Then they wind up having 3 kids. But the complainant seems to suggest, or had suggested that, well, I knew he was the man for me. I was for sure going to marry him. I never felt more comfortable with anybody in my life.
Well, simultaneously,
Right. Well,
apparently
yeah.
not being able to sleep a single night without fear.
That was the last night I was able to sleep comfortably.
So just so everyone knows, who raised this at trial?
I'm not telling right now.
Okay. Ooh, suspense.
But the consideration
We'll
of,
come back once we have a decision.
Okay. Exciting.
the consideration of whether or not
It's
the,
a cliffhanger.
It really is.
the defense may want to
For
go
me.
for it. Like mentioned, we've had other cases too.
I'm curious about what people will say when this airs.
Yes.
Yeah.
And what people's comments are. So we really are inviting it on this one because it's like
Raise it or not?
Well, the consideration is when you're looking at this massive
there's a
global
hybrid
charge,
answer to this as well,
Okay.
by the way.
When the charge is massive and there's claims that hundreds of assaults took
Right.
place, there's hundreds of sexual assaults, and so then how do you defend against that other than the accused just saying, "I'm mystified where this is coming from." We had a great marriage up until a certain point, and then we started to part ways and things got acrimonious, and but and that sounds reasonable. But how do you defend against that narrative? You can't address every single allegation because
So what's a motion for
global.
particulars? When would you do that?
I don't think anybody really does it anymore.
They really don't. It used to be you could ask the court to force the Crown to particularize, okay, well, what date? You've given me 20 years.
they gave a date from January 1st of this year to
No one
December
does that
31st
anymore.
of the other
You,
year.
you can bring a motion to particularize, but because of the way they treat complainant evidence and the large latitude given as to dates and times and everything else, I don't think it'll really help
Yeah,
you.
I don't see it anymore. It used to be a thing.
And in the global charge, there's not really specific dates given. It's just saying, I remember this thing happened twice, and I remember this thing happened 100 times, and then there was another type of event that happened like 3 or 4 times a week.
Over 20 years.
And then gradually that type of assault lessened from this year onward. So there's no actual particulars given other than just a time frame for
it.
ongoing
And there's plenty of
abuse.
cases where people are convicted on evidence that's similar. That's right. It may not be as extreme as what we're saying in this one case, but it's pretty close.
Right.
And people are convicted, even though there can be motive to fabricate and there can be some evidence of contradictions.
Right.
So I want to be clear on that. So the hybrid could be you object to ahead of time. You say the Crown has to bring a bad character and has to bring a prior discreditable conduct application to delineate what they're going to have admitted here.
Right.
And depending upon that answer, then you can make a determination at that point as to how you go about it. If the judge rules, not in your favor and says, well, 90% of this has to go in because of the way the count is somewhat particularized, it's got to go in, it's all relevant to that, then you've covered your ass by having challenged the evidence and gone through the motions.
Right.
But that may be all you have, right? It may be that what you're relying upon is what seems to us, maybe it's stereotypical, as the absurdity of these comments. And it's not so much, the hundreds of, this happens hundreds and hundreds of times, I find to be completely an exaggeration. And there may be, there are ways that you can think hypothetically that can be explained. But when you get into the other complaints and the other stuff, and then the narcissism, the psychopathy, the children, the everything, to me it just shows, it underlines what we thought was a motive to fabricate. It just tells you a lot about the complainant.
Animus.
Well, that's what I was going to mention is like the Crown prosecutors allowed to bring evidence and to establish a pattern of behavior and animus.
Right.
Although they can't argue propensity.
Right.
but
We can
the
argue
defense,
animus.
the defense can bring in the nature of the allegations and the wording and then the approach to making the allegations as a form of animus
Right.
and bad character of the complainant.
It's a tough one. I got to tell you, it's a tough one, and we'll see if it worked out in this case. But it's one of those things where I think we run up against what is stereotypical reasoning, what's discriminatory reasoning, and what's reality. And not always will we agree that all this is stereotype discriminatory reasoning. I don't know if I'm making sense for this episode. It was a real quandary. Just because of some of the things that were mentioned, there was just no room for any goodness in this human being. None. Not a fucking thing. I have no clue what the basis was of why this was the person I was going to get married to.
Right.
Or let alone have children with.
Right.
And we know that there's a lot of, there's going to be a over 20-year span of allegations saying that this was an ongoing regular thing. So you've already got that type of evidence going in that is part of the charge.
Right.
All of the other stuff just shows,
What does it show?
The pettiness.
Is it the pettiness?
over the top.
Like I want to drill down on this a little bit. This is where you sit around the table with your fellow counsel and you start to talk about it, and you and your experience. What does it show? I'm trying to get at the nub of psychology here, and challenge a little bit and push back on what is stereotypical reasoning and what is discriminatory reasoning. It's not always incorrect for us to say, when you complain this much, it's fucking bullshit.
Well, and it's all of the these really strange things, like an argument over whose fault it was that they messed up on who was picking up the kid that day, right? And this is a breaking point.
Therefore, I'm checking out at that point. Not because you raped me 966 times.
But I've
didn't pick
seen
up the
this
kids,
happen somewhat planned, because I'm talking about the case we did where we argued and had an expert saying that our client was actually the abused spouse, the battered spouse. And part of making that case was bringing up all of this stuff, all of these petty things and ridiculous things, like him being thrown out of his own condo because he tried to buy her a birthday present.
But we had a wonderful source of evidence. We had messages. Those two people, I don't even think they ever spoke to each other. There were so many messages. Everything was over WeChat. It was young Chinese couple. Everything was over. We had reams and reams and reams of messages that you wouldn't believe. You wouldn't believe the way he was treated.
He's late because the subway got stopped because of some sort of incident on the subway line. And she expected him to text her and let her know he was going to be late, but he couldn't because he was stuck in the subway and couldn't text. And he nearly got thrown out of the house for that.
He got reamed out for taking soup to his sick brother-in-law. But leaving that case aside,
this is another case, though, when you're asking about these specific messages, she just starts blurting out more and more bad character evidence, and you're just like, carry on.
Carry on, yeah.
Well, that was a perfect example, because at least we had this, 1,000 pages of messages that I could just show you're the abuser.
Right.
Yeah.
We don't in this case.
No.
And so it's a real judgment call. It's a danger. It's frightening, because we can be faced with a decision that says most of what you cross-examined on, the inferences you're seeking for me to draw, are really based on discriminatory reasoning.
That's right. But you're really, when you're going into a case where it's really a he said, she said thing, where there's not
this is absolutely he said, she said.
This one, yeah.
And it's just going to be his testimony. There's already going to be, because of the nature of the global charge, there's already going to be tons of allegations to be faced.
But we know very carefully that we have to try and narrow that field. We know we have to, cut back on the discreditable conduct evidence, because, God forbid, with a conviction, on appeal, that's going to be an issue.
But establishing animus becomes really important to say these allegations, if you just limit it to the nature of what the charge is, only the sexual allegations.
But what does the animus go to, right? What does the animus go to? The animus goes
fabricate, no?
Well, we may get faced with in our judgment, she fucking hated him because he was an abusive bastard.
Right. Doesn't mean it didn't
That's
happen.
the animus.
Right.
He created the animus.
Right. Yep.
We didn't have anything to ground it in, right? There was not one message, not two messages, nothing that we had to ground it in. It's just one person and the other. And you really feel the pressure in this case of a male going, honestly, like, the first 10 years was pretty good. Like, after that, we started to have real problems. Right. And here's what happened. And at this point in time, I was the one who said I want a divorce. And that was sort of the breaking point. And then things were really shitty afterward. And there's a few things that happened that, to his credit, he asked for counseling. And in this diatribe, she says, I fucking hated counseling. All we were talking about was how we can improve our conditions, not about my abuse. Right? So there were things to cross-examine on. They were somewhat interested. But, we can be faced with a judgment that says, look, most of this is based on discriminatory reasoning.
Right.
And it's not specifically relevant to, necessarily motive to fabricate, even though we think we tied it in.
I think the way they'd word it is it doesn't raise credibility concerns.
Yeah.
It's a possibility.
This is a really stark case, which I just felt for my own cathartic benefit. I have to bring this out because it's like, it's something that's hard to resist. Your natural instinct is to go, there's something really wrong here. Mm-hmm. There's something really wrong here. And
this level of hatred.
And this level of, demands a relationship with kids and he doesn't deserve it. I just think, even if we went to try and exclude everything, it wouldn't have made a fucking difference.
Well, and to keep in mind in this case as well, there's a claim that one of the reasons for not leaving was because he was always good to the kids. He was abusive to me, but he was always good to the kids. And yet we get into this, doesn't deserve a relationship with the kids. Right. So that's what I'm talking about. Like, there's some contradictions in there too, that without bringing in the bad character evidence, you lose the ability to bring up those inconsistencies.
It's true.
You have to introduce the Mount Everest of bad character evidence in order to get at the inconsistencies. And again, when you think back, these inconsistencies to us are important. Mm-hmm. Like, I think it's important when somebody says in their statement, no, he was always good to the kids. I stayed with him. He was good with the children, even though he was a piece of shit to me. Yet in this, basically you're saying you're a horrible parent. Right. Mm-hmm. But to a judge, it might be, well, at that point, she's just angry.
This made me think of another situation which we've encountered.
This is what worries me so much about these cases.
We've had other situations because we need to bring pretrial motions to get permission to use certain evidence and ask certain questions. And the Crown may decide to withdraw certain charges because in the pretrial motion, it becomes clear to them that we can show a major problem or even an outright lie with certain allegations. And that's a problem because then, that's something that you could have then used at trial.
Right.
We had that happen.
Yeah, to show that happened, or that they lied about that one thing. And if they lied about that, maybe they're lying about the other things. But if the Crown has the discretion to withdraw certain charges.
We had that happen. After our pretrial motions, which were 276, 278 motions, the Crown withdrew 2 counts. Mm-hmm. And we're going like, oh, I really wanted to cross-examine on that one.
Oh, yeah.
But in the end, it didn't matter. It worked out in our favor. But that's a good point.
There is a concern. Like, we had a client say, they were worried after the pretrial motion was won, that was going to somehow affect the nature of the evidence that the Crown was going to call at trial. And it would potentially change the complainant's testimony because they become aware of what was in the application to some extent. And that's another situation too, is like we want to cross-examine on something where we can actually prove the person's lying about it. And that does carry across too, if you find they lied about one thing. But then, you'd think it would be nice to have charges withdrawn before trial, but sometimes you want to go balls out.
Sometimes it robs you of a fruitful area cross-examination.
Go balls out. This other thing.
Just to go back for a second, so people don't think we were completely without a rudder here in this case. We were able to tie a lot of this into motive to fabricate, and there was questions about 2 pieces of timing that was very significant in our opinion, and one of them is the timing around when the complaint went to police, which happened to be right around the family proceedings, where there really is quite a bit of bitterness about division of assets and other stuff. We think which was significant enough for somebody to make an allegation in order to put him behind the 8 ball, because we know trying to force him into a position where he would not be able to defend himself. That said, I just from a strategic litigation point of view in a criminal case, you can see this is a true he said, she said. Nobody has any real documents to support their position at all. There's no messages. There's one recording here where you can't even fucking understand what they're saying. Most of it's unintelligible, so it doesn't really mean much. And it didn't factor in the case. So it's one of those things where it's a real judgment call, and that's where, you know, you rely on your experience as a lawyer, your gut feelings, and sometimes you just have to go for it regardless of whether at the end of the day it works, and whatever happens on appeal you have to live with if your client's convicted.
Right. It's always a possibility that a conviction can happen. It's just like you said, the concern here is that there's a strategic defense choice that then can't be a ground of appeal later on.
Right.
No, you're robbed of...
That can be huge.
Yeah, you're robbed of that, because our decision was not to oppose. We leaned in.
Yeah, well, in part because this 8-page document that was created was so compelling for so many different other reasons.
We thought.
Yeah, that you know, I think when you're already facing what's going to be allegations of hundreds of times, 3 to 4 times a week, you might as well go all the way.
4 times on Christmas.
Yeah.
Oh wow!
You might as well go all the way and just say,
yeah.
you know, vent your spleen. You know,
Knock yourself
what else
out.
do you have to say? And like you said, anything good?
Yeah.
Not a single nice thing to say about a man that she was apparently in love with.
But depending upon who your audience is, depending upon who your trier of fact is, that may not fly. Mm-hmm. It may absolutely, unequivocally not fly. And we've read appellate decisions where evidence was not this bad, but similar with the conviction.
Right.
A couple of them that we've reviewed are jury trials, which sort of underscores in this day and era where you don't have the ability to pick your jury, you don't know what you're going to get and what biases they hold. I don't care what fucking screening statement is made by the judge; it screens out nothing. I don't know. I'm very interested when this airs, what people's comments are, because people do comment.
Yes.
And I'm very curious about it because I think it sort of underlies a natural instinct that we have about where you smell bullshit and where it just seems too much, where somebody obviously hated somebody towards the end for what we suggested was a motive to fabricate, and that hatred carried into really fabricating the evidence, and it was so exaggerated, so over the top, so much bullshit without any redeeming qualities of him. It just was incredulous. Mm-hmm. And that's really the defense. But I am telling you honestly and sincerely, we run up really against somebody saying, well, that's discriminatory reasoning. It's not really grounded in something significant about a foundational piece of evidence that they're saying. And we said different. We said that there's certain elements that it's inconsistent with what she was saying. It's dangerous. We'll see.
We will. So, yeah, like you said, we read the comments. We read comments, and I think it's important for people to understand how complicated these cases are, and
this is a perfect
how difficult
example.
These decisions can be.
These tough decisions.
Yeah. Just alone to think about the cross-examination and develop it, and then develop, working with the client who is talking a lot about this. This is a lot of agony. It's a lot of agony. Because we want to try and do the best we can for the client, and you've got to make these judgment calls, and it's all on you. And you're well aware that if convicted, you're cutting off probably any chance of a successful appeal.
Right. I just kind of think, if you've got a waterfall, and then you've got a choice of extending the waterfall, which is massive Niagara Falls,
right.
and you're going to add an extra foot onto the end of it.
Right. That's a good analogy.
It's like you've still got a waterfall either way. And if that extra foot can give you something to cross-examine on and give you some footing to show the insanity of the person unrealistic.
Is there, and we're not going to answer it now, is there a point where it is too much? Where the bad character evidence and the prior discreditable evidence becomes too much? Where it is so
prejudicial? No,
where it's so overwhelmingly stupid. That it becomes
stupid,
detrimental to the credibility of the complainant.
Yeah. I was like taking.
Let us know.
I was
Let us
taking my
know.
analogy further and if you're Tesla, you could take that waterfall, make it bigger, and generate more power.
It's true.
I think it's a really good extension of the
It
analogy.
is.
Actually.
So this was a short one, but this was important for us to sort of
Vent.
get out. So
Yes.
I'm glad you followed along with it. Please, when this airs, as you're listening to this, please make comments and send us emails or whatever, because we read everything, and it's very helpful to us. And please
Don't forget to like, subscribe, hit notifications as
Share.
well, and share it with all of your
share.
friends.
let's thank Michael. Who do we thank? Our sponsor.
Easy DNS. Don't leave home without them. Or, well, I guess you can leave home without
You can.
them.
The whole
You can.
idea
That's
is
the whole
that
idea.
they're
that
a
you
web
can.
hosting
So you
service
can safely leave home.
right.
Yeah.
You can
So,
safely leave
Thank you,
home.
Easily DNS, for your support.
Yes.
They're an excellent web hosting service, highly secure,
And I'm a customer.
and you're a customer. So
Long time.
we highly recommend hosting your domain name and your services with EasyDNS. So thank you very much for your support. Thank you for viewing, and we look forward to your comments on this one. Good night.